Hi, good evening. Good evening, everyone. A warm welcome to all our friends and colleagues. I'm delighted to deliver the opening remarks for this year's Maxwell Lecture. The Maxwell Lecture series was launched in 2014. It was to bring the arbitration community together to engage with leading arbitrators, practitioners, and academics from around the world. And since our inaugural lecture in 2014, we have organized more than 25 lectures. Today, we have the privilege of having Professor Stavros Brekoulakis, who will be speaking on the topic Impartiality and the Construction of Trust in Investor-State Dispute Settlement. Now, Professor Brekoulakis is the Michael and Laura Hwang Chair of International Arbitration at the National University of Singapore. He practices as arbitrator from 3VB and is the author of numerous monographs, books, and articles. He's also a member of the ICA Governing Board, LCIA Court, NICC Commission on Arbitration, as well as the editor of leading law journals. Welcome again to Singapore, Stavros. We're also privileged to have with us today Dr. Michael Hwang, whose generous gift has established the Michael and Laura Hwang Professorship in International Arbitration to promote education, research, and development in our field. Our gratitude to Dr. Hwang. We're very pleased you can join us today. Very briefly on the topic of the lecture, Investor-State Dispute Settlement, ISDS, is a system that allows investors to bring disputes against states before international arbitration tribunals. Now, ISDS is currently included in thousands of international trade and investment agreements as the default system of resolving disputes between states and investors. Yet ISDS is also the subject of controversy and criticism. And a large part of this criticism stems from claims that ISDS lacks impartiality and is often perceived as being structurally biased in favor of investors and against states, with attention being focused on various reform options. Now, how does this impact the credibility and legitimacy of the system, which is necessarily founded on trust of its users? And how do we bridge the differing perceptions and address the existing critiques of the system? And in today's lecture, Professor Brekoulakis will confront these perspectives and the underlying assumptions and premises. As he notes, absent from the debate and reform proposals is the fundamental question of what is being assessed in the first place, right? What is this idea of impartiality against which ISDS is assessed? The notion of impartiality is important because it maintains legitimacy, fair process, and determination of legal rights. But what is the benchmark in ISDS? Is it different from impartiality in a judicial context? How is trust constructed across different dispute resolution frameworks? And what implications does this have? Now, there are no easy answers, but as practitioners, it's important that we confront the reality of our practice and deepen our understanding of the values, the beliefs, and the underpinnings of our field. And we can all ultimately have different views, but we cannot sidestep these questions. Today's lecture by Professor Brekoulakis is an important contribution to this global, evolving conversation. We hope it will spur further reflection and debate. And his lecture will be followed by a Q&A session moderated by Chian Bao, leading arbitrator. Thank you, Chian. And at Maxwell Chambers, it's really our privilege to host important conversations such as these, to promote thought leadership and to bring together perspectives from friends in the community. My gratitude to the Maxwell Chambers team for organizing this flagship hybrid event. And without further ado, Professor Brekoulakis, please.
Let's see if I can do this without glasses. Thank you, Daryl. I'm delighted to be here today and to give this lecture. I want to thank Maxwell, Chambers, and Daryl for the kind invitation. And of course, I want to thank Jan, who kindly agreed to moderate the Q&A session at the end. Now, for more than 10 years, the Maxwell lectures have been leading the discussions on important legal issues in this country, offering a wonderful platform for arbitrators, practitioners, and academics to engage in public intellectual debates. I'm honored to be part of these debates. As you can see, I'm still new in this country wearing tie. I think Rod ridiculed me out there for doing that. But I'll take this occasion that since it's my first public speaking in Singapore, I want to say that I'm honored to be appointed to an NUS chair, which bears the title of Michael Hwang and his wife, Laura. Following on what Daryl said, Michael has been one of the leading lights in international arbitration for several decades, and I can only hope that I can serve this chair, and more generally, I can serve the arbitration community in Singapore as best as I can in the years to come. What I propose to do this afternoon is to present the findings of the latest empirical project that I'm leading on impartiality in ISDS. I propose to structure my lecture as follows. First, spend a few minutes to discuss the project's approach and methodology. Second, give a brief overview of the context against which we carried out the project. And third, and finally, present the findings of that project. The main thesis of my lecture today is that the judicial doctrine of impartiality, which we currently use to assess whether ISDS is a partial or is an impartial system, is a poor fit to make this assessment and does not reconcile with the way trust, the value, the idea of trust in the appointment of arbitrators is constructed in ISDS. Accordingly, I will argue that we need a new, more nuanced approach to assessing impartiality, which better corresponds to the fundamental value of trust. Let me start with a few words about methodology. This is a large-scale interdisciplinary project which draws on law, psychology, and moral philosophy. The project team includes a trained psychologist and a specialist, and many specialists in international arbitration and national judiciaries. Of course, this is not the first empirical project in ISDS. While originally the field was dominated almost exclusively by doctrinal work, in the last decades, empiricism has swept across many fields of international law, including dispute resolution. We believe, however, that this project differs from other empirical projects because of the number and quality of the data that we rely on and which we have collected. Specifically, we conducted in-depth interviews and we collected value surveys from more than 100 ISDS arbitrators and arbitration practitioners. Importantly, the arbitrators who participated in the project have sat in more than 1,200 ISDS cases between them. We also interviewed representatives from all arbitration institutions which administer IS disputes, including ICSID, Stockholm Chamber of Commerce, the PCA, the ICC, and the LCIA. We argue, therefore, with some justification that the data of this project is both comprehensive and reliable, as this data comes from those people who have unique insights in the practice and understandings of ISDS. Now, before I turn to present the findings, let me take a step back and very briefly give a broader context within which our project is situated. As everyone in this room knows, and Daryl mentioned very clearly about that, ISDS is currently the subject of intense criticism. There's apparently a legitimacy crisis about arbitration, and ISDS in particular. But I think this is more a legitimacy about whether the system is partial or not partial. There's this claim that parties are paid, because parties are paid by parties, the system accounts for an inherently biased, structurally biased system of justice. I often ask many commentators who object to arbitration, what is the problem with ISDS? They all eventually come to this point. The problem is not arbitration. The problem is who decides. As a result of this legitimacy crisis, this claim that the system lacks impartiality, states are now seeking to amend ISDS to address issues of impartiality, among other things. Two different approaches, two different options are currently considered. The first is a root and branch approach to replace ISDS altogether with a system of court-based adjudication. As I mentioned, the idea here is that arbitrators tend to be biased because they are appointed and paid by the parties. So if we have permanent judges paid by states, impartiality would be restored. The second option focuses on proposals to reform, not replace ISDS, but introducing more rigorous standards of conduct of arbitrators. The idea here is that arbitrators tend to be biased because there are no comprehensive rules to regulate their behavior. Now, if we introduce such a rigorous set of rules, impartiality again would be restored. Notably here, the Code of Conduct for Arbitrators in ISDS that was very recently published by ICSID and Ancestral includes far-reaching disclosure requirements for arbitrators. However, absent, I would say, from the debate and the reform proposals is the fundamental question of what is being assessed in the first place. To credibly assess whether there's an impartiality problem in ISDS, you need to first identify what we understand by impartiality in the first place. In other words, you need to first identify the yardstick of impartiality that we are using to measure ISDS. And the yardstick of impartiality we currently use in ISDS is a doctrine of impartiality, which was developed for and has been applied to national judiciaries. The UK Supreme Court in Halliburton and Chubb said this, and I quote, "The objective test of the fair-minded and informed observer applies equally to judges and all sorts of arbitrators, irrespective of whether they act as a presiding arbitrator or party-appointed arbitrators." The same doctrine of judicial impartiality applies to everyone, national judiciaries and arbitrators. But why should this be the case? It is striking that no one has questioned why a doctrine that was developed to serve national judiciaries was altogether transplanted to a system of justice that was developed as a distinct system of justice with a fundamentally different procedural design, aiming to function as an alternative to national courts. The idea that the same judicial doctrine of impartiality applies equally to judges and all arbitrators is predicated on an absolute approach to impartiality. Such an absolute idea of impartiality suggests, I would argue, three things. First, that there's only one universal conception of impartiality that applies across all methods of legal adjudication. Look at the recent Code of Conduct in ISDS. It explicitly applies to all adjudicators, irrespective of whether a person sits as an arbitrator, as a judge, or as a member of an ICSID annulment committee. Second, it suggests that only a singular duty of impartiality exists and applies irrespective of the role of an arbitrator. Whether an arbitrator acts as a SEP, as the chairperson, as a sole arbitrator, or a party-appointed arbitrator is irrelevant for the existing doctrine of impartiality. Third, it suggests a binary approach to impartiality. On that view, an adjudicator is either absolutely impartial or otherwise biased altogether. Any form of partiality, even in the form of an implicit bias, is neither acknowledged nor accounted for in the judicial doctrine of impartiality. The Court of Appeal in Halliburton said this, and I quote, "The risk of unconscious implicit bias does not affect the relevant legal test for bias. It provides an example of how bias may act or appear to act, but it's not part of the legal test." The broader thesis of this project is that impartiality is not an absolute idea which applies across the spectrum of legal adjudication. While impartiality has a core principle which requires to approach decision-making with an open mind, the conception of impartiality operates differently depending on the context in which decisions are made. The findings of the project demonstrate that the context in which decisions are made in ISDS is this idea of trust, which is constructed around the system of party-appointed arbitrators. And let me now turn to the findings of the project in more detail. Let me start by showing you the first two quotes for today. We have hundreds of transcriptions from interviews, but I only have time, obviously, to go to a very few quotes today. I quote, "Arbitration is based on a system where you trust one person and you take the risk with that person. That's it." Another one said this, "How do you get a party to trust somebody sufficiently to appoint them?" And that's what it's all about. Throughout the empirical project, the party's ability to appoint ad hoc arbitrators who they trust was identified as a fundamental value of international arbitration. Indeed, the party-appointed system is regarded as a cornerstone of the legitimacy of international arbitration. It leads to trust in the arbitration process as a whole and trust in the outcome of the arbitration. And I quote, "If one is opting out of the judicial system, then the opportunity to have the option to be involved in the selection of the decision-making body is fundamentally important to a sense of participation and ownership in, and therefore trust in, that decision-making body." But what exactly does this idea of trust mean? The evidence suggests that it means a number of things. First, at a fundamental level, it appears that it means that you appoint someone who you can trust to ensure that the process will be fair and that the parties will have a fair opportunity to present their case. So it means trust in the fairness of the process. And I quote, "I suspect that the reasonable expectation of parties in appointing a party-appointed arbitrator is that it will help increase the chances of their case getting a fair hearing before the tribunal by having a party-appointed arbitrator in place. A fair hearing where all parties have a full opportunity to be heard." However, in ISDS, the expectation of trust goes beyond, far beyond fair hearing. It crucially means that you trust that the arbitrator you appoint will understand your case and understand it in its proper context. And I emphasize context here because given the unique political and national sensitivities surrounding IS disputes, the context of a party's case might be important. Now, interviewees identified two qualities that an ISDS arbitrator must have to properly understand or be trusted to understand the party's case in the right context. First, that an arbitrator must share similar perspectives with the party who appointed them. Those perspectives can be legal or non-legal. Next, please. And I quote, "But they are also looking for, I think, an understanding of their perspective. So if it is an investor, an understanding of commercial investment, risk, and protections. If it is a state, a perspective of how a state functions, how democratic process works, if it is indeed a democracy, and how laws are made and how people are protected within the state." So I don't want to use the word ideology because I don't think this is the right word. I think the right word is perspective. If one has never worked with a state or for a state, there's a lot of state lawmaking process, state governance process that you don't really appreciate. So I think it is that perspective. One the interviewee called party-appointed arbitrators as cultural translators. Now, this is from the second thing that parties are looking, the second quality that parties are looking for an arbitrator to trust is that the arbitrator must have the right expertise, which is necessary to better appreciate the perspectives of that party. This is from counsel who typically works for investors looking for commercial expertise in arbitrators. there's certainly an argument that if you're having a dispute about the deep sea horizon or the deep water horizon, you want somebody who knows something about oil and gas law and norms in the oil and gas industry and knows about oil and gas contracts. Conversely, a state party will typically look for public international law expertise, i.e. expertise of someone who understands the limitations of a state liability under public international law. And this is from counsel who usually works for states and appoints arbitrators for respondents. And I found that very interesting. And I quote, and that's when I thought we need completely different expertise. We don't need the arbitration gurus. We need public international law specialists in these cases. And that's when I started to appoint a different type of lawyer to these cases. I was clear that we needed a very different specialty, a very specialized area of law. And it is not private, commercial, or transactional as I thought it was. Now, if parties appoint an arbitrator because they trust that an arbitrator shares the same perspectives and expertise which is useful, what does that mean for the idea of impartiality in ISDS? In other words, what are the implications of the value of trust as I described it for the idea of impartiality in ISDS? Our findings show that trust in the appointment of arbitrators, this idea, this process that I described, affects our understandings of impartiality in two different ways. First, it means that the parties trust that the specific perspectives and expertise of their party-appointed arbitrators will lead to a degree of predisposition favoring a case of that party. There's an overwhelming evidence on that, demonstrating the point. I've only included a few here. First, and I quote, the first item for me is to draw a list of people whose decisions might go to some extent in the direction of the legal issues or in the direction of how we want the legal issues in the case to be decided in favor of the client. This is our first criterion. An overwhelming also number of interviewees indicated that this sort of predisposition amounts to some form of bias. And I quote, yes, and of course, this does definitely go to your bias in the broader sense of that term. I think that you do look for a predisposition. If you're a claimant's counsel, that someone is not going to be too statist. And another one, that's one of the things you look at when putting up the tribunal, that I think is or should be one of the values of arbitration, that you have people who understand what the dispute is about, that brings with it some element of bias. And another one, what I'm focusing on is that it's not a question of being honest or dishonest. It's a question of being rather involved in certain areas rather than in others, more knowledgeable in one area rather than another, that may lead to what we perceive as bias. Now, the fact that arbitrators are elected in large part for their predisposition is something that arbitrators are actually conscious of. One favorite quote of mine from a prominent arbitrator is this: I'm struck by the fact that although I do not believe I'm partisan in any way, every time I have dissented, he has been in favor of a party who appointed me. I think about that a lot. He has been in favor of the party. I think about that a lot. It tells me at a minimum the notion that counsel and parties are trying to choose party-appointed arbitrators who are philosophically predisposed towards the conception of the case must be working to some extent, because I find myself saying, here's how I think about the law, here's how I think about facts. Then I'm outvoted 2-1. Maybe that my dissent consists of one sentence. That realization, I think it is important. The second thing that trust means is not just that you trust that the arbitrator will carry with him or her, some form of predisposition, but importantly, that they will able to carry those predisposition into the deliberation room. And I think that is something that the project for the first time brings up. And I quote, at least from a counsel's perspective, that's what's key, that you want to at least have people who If they have these positions, the strong views that they may have on certain issues get properly debated within the tribunal, and then ultimately the deliberations lead to whatever the result is. And another one, so you want two things. I want set views and to be able to carry those views forward in a persuasive way. Interviewees mentioned that bringing these set views in a persuasive way in the deliberation room is part of the party-appointed arbitrators, and I quote, mandate or duty or job. I quote, he does have a job, said one interviewee who clearly thinks that arbitrators are only male. Any arbitrator does have a job to make sure that the party that appointed them is able to get their case out. I mean, that's a fundamental role that they have. They need to make sure that all of the arguments are well vetted. You rely on the other party appointed to do that for the people that appointed them. And another one, it's the duty of the co-arbitrator to see to it that the standpoint of the party that appointed him is duly considered, the same way that the other party's standpoint is duly considered. Now, this job, this duty of party-appointed arbitrator who carries a degree of bias with it, again, there's a lot of evidence to that extent, and I quote, the duty of the party-appointed arbitrator is to put the position, to make the tribunal understand the position of the party who appointed him or her. That is more and more in the borderline of leading for the party. As I say, there's overwhelming evidence suggesting that the value of trust, which prevails in ISDS, brings about certain forms of bias, or at least a degree of predisposition towards the party who appointed them. Now, if we circle back to the judicial doctrine of impartiality that I described earlier, it is obvious that the understandings of impartiality in ISDS do not readily reconcile with the absolute nature of the judicial doctrine of impartiality in national courts. An absolute doctrine of impartiality makes good sense for judiciaries. Indeed, the doctrine of impartiality in the judiciary has public law, constitutional law origins. It developed as a constitutional theory in the 18th century to ensure that the judiciary maintains entirely separate and impartial from the executive. The constitutional doctrine of the separation of powers depends on an effective doctrine of judicial review. In this constitutional context, judges must be strictly detached from the disputing parties and, of course, from the executive. Exhibiting any forms of bias or taking account the perspectives of certain parties is considered incompatible with the role of the judiciary. You do not appoint judges because they can better understand or are sympathetic to the perspectives of the executive. However, while an absolute doctrine of impartiality has worked very well, both as a matter of practice and a moral foundation for national judiciaries, arbitration has a very different doctrinal and historical origins. Indeed, arbitration evolved as a private theory of adjudication, not a constitutional or public law one. It came about as a distinct system of justice, which is alternative to judiciaries and sits outside this constitutional triangle of legislature, judiciary, and executive. Historically, arbitrators never had a judicial function. Rather, they were treated by law as agents of the two disputing parties with a mandate of finding a solution to the dispute. As I've shown in an earlier work of mine, court decisions in England from the 19th century demonstrate that the courts classified arbitration agreements at the time as agency contracts, under which arbitrators had fiduciary, not judiciary powers. This ad hoc party-appointed system in arbitration is the corollary of the historical treatment of arbitrators as agents whom parties appoint because they trust them and place upon them fiduciary duties to resolve their case. Of course, arbitration as a justice system has greatly evolved in the years since the 19th century. But the fundamental idea of a party-appointed arbitrator as a trusted decision maker who has a certain duty towards the party who appointed them remains, is still valid. Again, the evidence from our research shows that even today, arbitrators are alive to that fiduciary trust placed upon them by the parties. And I quote, "You have to recognize that you're fulfilling a special function You've been entrusted by the parties who appointed you. It is important to honor their trust in you and not exceed their trust in you. I do think that there's an extra level of care towards the party who appointed you. In that sense, the trust in arbitrators is constructed in very different bases from the trust in judiciaries. When two parties decide to submit their dispute in national courts, they cannot choose the perspectives or expertise and experience of the judge who will be assigned to their case. Rather, they choose to resolve their dispute in a national court because they trust the system, the court system of that jurisdiction as a whole. In other words, it is trust in the judicial system which leads in trust in the individual judges. By contrast, parties in ISDS trust in the individuals because of the particular attributes and qualities that these individuals have. So it is the other way around here. It is the trust in the individuals which leads trust in the system of justice of ISDS. The system of ISDS is a non-integrated system of justice, and as such, it is as good and trustworthy as the specific arbitrators who are appointed to decide the case. And I quote, I mean, the entire arbitration is all about appointment of arbitrators. In other words, parties can actually choose who is going to be the decision maker. And I think this is what really makes arbitration different from litigation, for instance. So yes, it is essential to arbitration, and it is very important to keep it that way, in my view, because that really enhances the trust in the system and confidence in the system. Now, the fundamental difference in the construction of trust between ISDS and judiciaries entails a different understanding of impartiality. While any degree of known or active predispositions in national courts would lead to a disqualification of a judge, this form of predisposition is considered compatible with the idea of impartiality, which exists in the context of ISDS, and I quote, "You have to accept party-appointed arbitrators. The party appointment arbitrator has an inclination towards. That's why also I don't mind. I do not mind. I think it's normal." And another one, "Yes, and of course, this does definitely go to your bias in the broader sense of the term. To me, that's fine. That's a fine example of legitimate predilections. That doesn't mean that they're going to decide in any case in any particular way necessarily, but to me, that's a completely legitimate bias. If you want to use the term, obviously, the term is too strong. Predilection is better." Now, let me emphasize here, the different understandings of impartiality in ISDS does not suggest that the practice of ISDS, or more generally in international arbitration, is unprincipled or ethically compromised. Indeed, the system of ISDS in international arbitration is heavily regulated by a wide range of ethical rules, and guidelines. And despite the criticism, examples of unprincipled behavior of arbitrators are truly very rare. Speaking on this, one interviewee said this: "It doesn't mean that they're not impartial, and it doesn't mean that the system is any less legitimate in terms of impartiality." And another one, "It's a different understanding of impartiality. Whilst in international arbitration, we've increasingly fallen for the idea that these people are judges and therefore must be impartial, I think it's a misunderstanding of what international arbitration is, what arbitration is all. It's at all. The parties want to keep a finger in the pie, and that's also necessary for its credibility. It's a credibility issue. It's taken away from the parties. If it's taken away from the parties, they don't feel any kind of connection with it, and I think they don't like it." To conclude, the findings of the project show that first, trust in party-appointed arbitrators leads to some sort of predisposition or partiality. Secondly, this form of partiality is generally accepted in ISDS as part of our understandings, the different understandings of impartiality. Thus, and thirdly, our understandings of impartiality do not reconcile with the current doctrine of impartiality that requires that all adjudicators, irrespective of the context, irrespective of the role, irrespective of what kind of form of adjudication they work in, are absolutely impartial or otherwise biased. Ultimately, the findings of the project call for a new assessment of impartiality in ISDS, which is more nuanced and which can better correspond to the foundational value of trust in ISDS. In this nuanced approach, certain forms of partiality can be compatible. And let me say this by way of broader observation. Special concerns, intuitions, even strong emotions and passions need to be recognized as a form of acceptable partiality in legal decision-making. This is not the case currently in law, where the test of impartiality is exclusively informed by this idea of this third-party observer, which is entirely dispassionate and rational. In this sense, legal thinking is still under the ideological grip of a long line of Western thought from Plato to Immanuel Kant and Jeremy Bentham, suggesting that rationality is the pure form of reason, including legal reason. The idea here is that passions and intuitions make human reason unfit to judge what is good or what is evil, but to insist that legal decision-making is carried out as a neutral, emotionless, dispassionate, and impartial exercise flies in the face of insights reached in psychology, moral philosophy, anthropology, and neurobiology, which have demonstrated that human cognition works together with emotions and partialities in shaping our perceptions and decisions. Even by law's well-known insularity and unwillingness to learn from other disciplines, this absolute demarcation between reason and emotion, decision-making and partiality is unsustainable. Faith in pure reason is nothing more than a rationalist illusion. It seems to me that we in law, and certainly in ISDS, we keep operating under this rationalist illusion, requiring all arbitrators, irrespective of their role, background, context, and perspectives, to answer to the same unattainable standards of impartiality and be free for any form of partiality. Now, I appreciate that this call for a more nuanced and contextual understanding of impartiality might lead to some form of apprehension. And to allay this apprehension, two issues need to be further addressed. First, the fact that certain predispositions can be considered compatible with the understandings of impartiality in ISDS does not mean that all kinds of predispositions are equally compatible with it. The call for a new approach to impartiality is certainly not a license for arbitrators to be partial. Impartiality is still, and I want to underscore this point, the lodestar of ISDS and international arbitration. So in principle line between some forms of permissible partiality and some forms of impermissible impartiality must be drawn. Second, empirical findings alone are not sufficient to support a new doctrine of impartiality in ISDS. It is important to build a strong theoretical foundation, a strong theoretical framework, and an ethical basis to support the suggested new approach. These issues are considered in subsequent work of ours, which sets out the theoretical and moral foundations of this nuanced understanding of impartiality. As we argue, the critical question there is not whether an arbitrator can meet universal standards of impartiality, irrespective of the context within which this arbitrator operates. Rather, the critical question is what standards of impartiality are reasonably expected from that arbitrator, given the specific context and role in which that arbitrator operates. We further suggest that the principled line between permissible and impermissible form of partiality is the idea of open-mindedness. I do not have time to speak about this tonight. I've already exceeded your patience, but I do hope that I have the opportunity to discuss this on another occasion soon. Thank you very much for your attention.
Thank you very much for that insightful lecture that you gave, and certainly gave us much food for thought as to whether our system works and how to improve it. Right, we have a question from the floor, actually online. Oh, let's take one from the floor first. We've got Rod in the back, yes?
You've mentioned how party-appointed arbitrators are expected by the parties who appointed them to make sure their case is fully vetted. And that may imply a predisposition, but at least that the arguments are fully vetted. Now, that's precisely the same thing that states consider when they're naming a judge ad hoc before the ICJ or before the Hamburg Tribunal. But there's a difference. In the ICJ, each state names a judge ad hoc, effectively a party-appointed arbitrator or judge, but there are 15 others. So there are only 2 out of 15. And in ISDS, you have a tribunal of 3, and we haven't spoken about the third person. And I'm wondering, and even in state-to-state arbitration, normally the panel will be 5, 2 party-appointed arbitrators and 3, I'll call them so-called neutrals. What about this third party, this presiding arbitrator in a panel of 3, and the notion of impartiality? And is 3 the right number? Should we be rethinking the number of should an investment tribunal consist of 5 members?
Thank you, Rod. I think you raise at least 2 very valid points, taking them in reverse order. The number, I think you say something that is very valid. I think probably a panel of 5 would have made more sense and who have inspired more trust in the decision-making process and the outcome. I suspect that the reason we ended up with 3 is practical issues of cost and the impracticalities that a bigger panel carries with it. I suspect it's more a question of whether we are more practically comfortable with the 3, but 5 from that perspective would make very good sense to me, especially bearing in mind the sensitivity and the large amount of money that are involved in ISDS disputes. So I hope that, that instead of throwing the system altogether outside, we can improve it along those lines and have probably more enhanced numbers of panels. Now, the other point that you made was the comparison to state, and you're right. There's a broader spectrum of arbitrators, there's a broader spectrum of interests. And I think that's the difference there. When you have a dispute in an ISDS, you only have 2 parties. When you appoint someone in ISJ, there are broader principles that you don't know how they will play out in a case. I suspect this is the reason. And I suspect this is why we have a permanent body of adjudicators in the national courts there than we have in ISDS. ISDS is an ad hoc system of justice. You have the dispute first, and then you figure out who do you appoint as an arbitrator. And I think that's a difference. When you appoint someone in the ICJ, you don't know what sort of disputes they may come up. But of course, you have a broader sense of the interests of the party who appointed them. So
precisely what the dispute is. For the sitting 15 judges or however many, they're elected by the Security Council and General Assembly, so they don't know what disputes. That's true, but not for the judge ad hoc.
Right. But I think there are some similarities. There are some differences in the way that ICJ decides and the way that ISDS. But I take the broader point that you say.
We have another question right here.
And just to follow up on Rod's point, there are different ways of treating arbitrators in state-to-state disputes and in investor-state disputes, and the practice of state-to-state arbitration shows that with the, for instance, the challenge of Judge Greenwood in the Mauritius United Kingdom case, where he was challenged by Mauritius because for a variety of reasons, but inter alia because he had been counsel for the United Kingdom before the International Court of Justice in a number of cases. that is precisely the kind of challenge that would have been successful in ISDS. In that case, it was rejected, amongst other reasons, because Mauritius had invoked the IBA guidelines on conflicts of interest, which the tribunal found to be, or the appointing authority that decided the challenge found to be inapposite in a state-to-state public international law dispute, because they were private rules accepted in a commercial context. And the question I ask myself is, now with the new code of conduct in ISDS, would that be different? And will state then accept that more as a form of, in a way, customary international law accepted by states, because the code was accepted in the UN context, in the UN Central context. So it may be different. So I'd be curious to know what you think about the code, since that was not mentioned. And just to pick up on Rod's point, I also noticed that the study, in particular, what you said this just now, you probably didn't have the time, did not deal with the position of the chair. And I would be curious to know what kind of answers did you get in that regard?
Absolutely. Thank you, Loretta. And I think, I forgot to address Rod's point. The question of chairperson is a very different discussion altogether. And we have an article only on the role of the chairperson. But that's the main idea. You can't treat, or you can't apply the same ideas or understandings of impartiality to party-appointed arbitrators and the chairperson. You have to have someone that has a very different standard of impartiality, and that's the role of the chairperson. So whatever I say doesn't apply, and thank you for giving me this opportunity, it doesn't apply to the person that acts as a chairperson, the presiding arbitrator in an ISDS or any other arbitration. Now, in relation to the point that you said about Greenwood, that I think that also demonstrates that if you try to apply the same conception and legal test of impartiality across all forms of legal adjudication, it just doesn't work, because state to state have different considerations. They have different practices. They have different origins. They have different traditions. Because I think there are different forms of justice. The only thing, what we have is this idea of appointment. But if you think they develop to serve different purposes, as I said, national judiciaries came about to serve this separation of power doctrine. It's a constitutional public law theory. And there, the expectations that you will be entirely impartial, especially from the executive that appointed you, are very different that you have in private forms of legal justice, private theories of adjudication. And I think that is the difference.
Question back there. Amanda.
Yeah, just picking up this point about the chair, won't this, I mean, I think this is fantastic work and very interesting, but won't this lead to even more of a division, such that you have basically three categories of arbitrators in ISDS? You have the state appointees, you have the investor appointees, and you have the chairs. Because if you're suddenly going to recognize predisposition, and it's going to become sort of not just, what the sort of people on the inside know or what people think perhaps, but a little more marked, then you're going to sort of very much lead to three buckets. And, there are people who say, well, why am I classified as a state appointee? Or why am I classified as this? And,
I don't know why would people ask the question. I think it reminds me of the quote of this arbitrator that said, well, I don't know why I vote that way, but I find myself outvoted all the time. It might be the experience that you carry with you, the traditions that you have with you, the expertise, the focus, the previous works. If you've been in a state council, you've worked for someone that is very closely to the state, it's one thing. If you worked in private business all your life, you carry with you different experiences, different understandings of how law should work, different understanding of what would be the proper law, the role of the state. We all have legitimate differences of how we believe a state should work, how we believe a state should be liable or not liable. What are the limitations? And these are things, I think, that classify you as someone that you have some considerations that might favor the practice of the state, and some others that would think that the state, even in IAS disputes, is just nothing more than any other normal private party.
But then who is going to be the chair?
Well,
So
there are.
who is going to be this mythical chair who doesn't have sort
Well,
of
actually-
state experience, involvement, but equally doesn't have the bias for the private investor from the private involvement. I think that's going to be the challenge.
And I think the practice shows that there are plenty of wonderful people that have carried that role remarkably well. So I think that is, a practical question that doesn't need a solution. We have the solution already.
Great. We have a question here with Tulio, and then I see that we've got a few questions. Oh, and over there. Great.
Just coming back again on the question of the practice in interstate jurisdictions, I'm wondering whether you see a clear, so whether you were able to see among your interviewees from public international law background, whether they had a stronger perception that the role of a party appointed arbitrator should advance the position of a state, whereas perhaps interviewees from a commercial background jurisdiction might not have exhibited this kind of stronger view. And on the question of the number of arbitrators, I would go to the other direction perhaps, and why not we should consider investor state tribunals with sole arbitrators. There have been one case, at least, that I'm aware of. There have been interstate cases with sole arbitrators, although they have been the exception, of course. There are other considerations that we need to keep into account, but perhaps the lesson here is whether it should be more flexible with the number of.
I'll start with the last question. I think we would lose a lot of very useful dialectic processes and discussions and debates in the tribunal. You see, if you have an open-minded tribunal, yes, you have your predispositions, but if you have 3 open-minded arbitrators, the discussions that we're having, the understandings that we change, I think this is part of a continuous dialectic process. It's very useful. It's very valuable in arbitration. I don't think that it is appropriate to decide this kind of disputes with one person. You would lose quite a lot of the dynamism, the wealth of experience, the wealth of different positions. And again, I emphasize on open-mindedness. If the discussion is on open-minded, even with people that have their views, you move along the thinking and you find yourself that you've moved along. You initially thought something, and then after the discussion, bona fide discussion with people that you trust within your profession, you think that you probably now see things differently. And I don't think that this kind of dialectic process would be possible to happen with a sole person that has multiple personalities. But I just don't think that this kind of wealth of discussion should be abolished. I think 3 or 5 would be a viable system to have. Now, the other question that you asked about, we didn't ask what is their position, whether they favor states. That's not why we wanted to do that. But I think you could see that people that have this public international law background were more willing to discuss about the role of the public interest and the importance of the public interest in deciding the disputes. That's something that I think carries with them more weight in their considerations in the tribunal. And that's something that probably someone with a more commercial background and approach don't necessarily have. So while we didn't ask the question, obviously, whether you fair, that's not the point. The point is that different experiences lead to different considerations. As a starting point for an open-minded, bona fide discussion.
Right. I'm going to go back and forth on sides, but I'm going to first take the my moderator's prerogative and ask myself a question, and that is the humanness of the impartiality point that you bring to life in your study is quite familiar, I think, with us as humans, as we try to understand what it is to be impartial and build a system of trust. The question is that we have built some constructs like the IBA guidelines and also now the new code of conduct. Do we need to be throwing those out because they don't actually test the proposition of impartiality, or do we need a personalities test? Like, what are we looking for to really satisfy ourselves of the real test of impartiality that satisfies the legitimacy of the system?
And I think that's a valid point as well. I don't think we need a personality test. I don't think that we need to throw out all these codes of conduct. I think they're useful. They serve a practice, but they're not panacea. That is the point I was trying to make. We thought that by developing these rigorous sets, we will somehow dispose of any forms of partiality of the system. And that's not simply the case. They have their limits, and they should be seen as having those limits. They are useful, sensible codes. Of course they are. You know, they are important. Our human nature and our human mind works better through these anchors, and we need these anchors. Of course, we do need them as a starting point. But are those guidelines going to take care of the issue of our predispositions? No. You know, what we need, how this translates to legal doctrine, I don't know. It's not something that I have, I think, so far developed. But I think we need to pay attention to what the findings of empirical surveys show about that. And that was the broader point.
I mean, it could be a combination of the use or reference of the code of conduct coupled with the reality of a study like yours, right? I'm going to take Lawrence and then Alistair.
Thanks. Thanks. Stavros, I'm so glad you made a reference to Western philosophy, and I'm going to engage you at that level. It seems to me that at the very base level of ISDS, and indeed international commercial arbitration, is the Western philosophical, is the Hegelian dialectic of thesis, antithesis, and then synthesis. And that works very well in party appointments, particularly in Tribunal of Three. People buy into that dialectic, but once you get out of that dialectic and you have a panel of arbitrators not appointed by the parties, then the tribunal members don't feel the compulsion, to use a hip hop term, to represent behind closed doors to ensure that the case of the party appointing them is properly debated.
That is, of course, true, but they still come into the deliberation rooms with their own views, their own predispositions. And as a rational person, I should say, you believe in your views, you think that these views are valid, and you need to carry those views into the deliberation views in the room, even if you don't think that you do that as a form of a duty, of a mandate that you have for the party. So even if you don't have party-appointed arbitrators, you see in this deliberation room strong discussions still. People disagree still. Why? Because they carry different predispositions, different forms of partiality with them. So that's natural, as you just said. It's a form of dialect that goes on in any kind. I mean, as we do now engage in a form of dialectic discussion, because we have different approaches to these things. So the party-appointed system does influence that, amplify that quality, but it's still there.
Alistair.
Stavros, thank you very much. You've titled your presentation and you framed your presentation by reference to ISDS. And I'd ask you perhaps just to explain why, if you think it is necessary, that you distinguish this from commercial arbitration, because if I appoint an arbitrator in a commercial dispute, I might choose to have a civilian or a common lawyer, or somebody who I think has a black letter approach to a contract, or somebody who has a more equitable and commercial approach. I might go for a contractor-friendly or an employer-friendly arbitrator. Is there any distinction here?
No, absolutely right. Well, I should explain. We started to look at ISDS because of this discussion, the legitimacy and the crisis. At the time, we had funding to do that. So our main focus was on ISDS, and the questions that we put to the interviewees were on ISDS. But some of the remarks, and that's in many of the evidence, show that the same considerations largely apply to commercial arbitrations because of the reasons that you just said. You want an arbitrator, even if you appoint them in a pure construction dispute case, you want someone that has certain views on this matter, and you want them to guide them with them in the deliberation views. There's nothing entirely distinct in ISDS. I should say, though, that the nature of the disputes, the politicization of the disputes to some extent, the large numbers, and the state's involvement in the public interest weighs more heavily on the shoulders of some party-appointed arbitrators. And again, from practical experience, but in large, it is the same discussion that we can have in a commercial arbitration setting. Yes, you're right.
I think we have time for these last 3 questions here.
Hey, Stavros, thanks so much for the really interesting presentation. I wonder if a domestic public lawyer would think that the Halliburton and Chubb impartiality standard is all as strict and rationalist as it's painted to be here. In particular, I'm not sure that a judge's philosophical predispositions, even their strong ones, would necessarily cause them to fall foul of it. If you are a victim of what you perceive to be domestic abuse, I think you would be happy that Lady Hale was hearing your case. I think if you are a government lawyer working in national security, I think you'd be happy that Lord Reed and Lord Sumption were hearing your case. But I'm not sure they fall foul of that test in the same way that Lord Hoffman did in Pinochet #2. Are we talking about a very different kind of radical philosophical predisposition in the ISDS context that falls foul of even this standard? Or are we maybe saying that domestic standard is actually broader than the rationalist paradigm that we're talking about here?
No, I just think that this idea that the common law test on impartiality captures is an unattainable idea. I think it's more an aspiration. It is more a legal doctrine that we have to look at. But if you try to apply that in practice, you see that it falls short of actual realities. So as I said, this may work as an aspirational idea for ISDS, for domestic judiciaries, but I don't think that the legal theory behind arbitration makes it as compatible for that test. Maybe.
Right, we have 2 more questions here. We have a few questions here, but I'm going to have you, because of timing, I'm going to have you respond personally to them. All right.
Thank you, Professor, for your comments and for insightful presentation. My name is To Shin Hao from the Attorney General's Chambers of Singapore. So although I'm from the government, I would like to raise an issue that's related to the outside, which is the investor. My thinking is that we need to consider the whole point of investor-state dispute settlement. It is actually a one-way dispute settlement process where the claim is filed by the investor. It is not for the state to file a claim. So because of this, the focus should be on the investor. And underlying this for ISDS is that the investor sees that the domestic court system of the whole state is inherently biased against the investor. That is why the investor goes to ISDS. So when he goes to ISDS, he has a fighting chance by having the opportunity to appoint one arbitrator, which is a much better situation than in the domestic court. So what are your views about looking at this from the point of the investor?
No, I understand why investors want to go to ISDS rather than go to a national judiciary. But again, we need to understand what kind of national judiciaries we're talking. They're not all the same. They don't have the same quality. It's one thing to see, and again, just to speak about the judiciary here in Singapore. There's a strong judiciary, independent, with a rule of law, the same as in the UK. I don't think that anyone should reasonably have any considerations, any concerns of going to hear their case before national judiciaries in Singapore. But it's another very different proposition if you go to Mauritanian courts, where there might be some different considerations as to how judiciaries there are appointed and how is the connection between judiciaries and the executive. So yes, I understand why an investor would want to go to hear a case in a tribunal rather than a national judiciary, but again, depends on what national judiciary I think we're talking about.
Great, thank you. Matt, we'll end with you.
Thanks, Stavros. That was a question specifically about decision makers, the decision makers. You put a really good case when you do it, right? Yeah, probably because. And the thing is that this would only be tested, of course. I mean, there's obviously an assumption that arbitrators are impartial. It's only tested in the case that they're challenged. And there you have kind of a twofold challenge to any new framework you put forward. The first is that the evidence of impartiality is always a bit fractured, right? When you actually decide challenges in institutions, it's always based upon kind of little bits and pieces that suggest impartiality. And then, of course, you have to have some decision maker, whether it be the other arbitrators or the institution or somebody else. And they themselves have certain predispositions. And when you have a line ball challenge, which is obviously the only ones that are interesting, I mean, the question is, would a new framework just be open to subjective, the subjective assumptions of the person deciding anyway?
True. I think you're right. And I think it's inherent in our decision making. I think that was a broader point, that we all, at some point, fall prey to our own predispositions. How we go around this problem, that eventually how you test whether someone is impartial needs to be decided by somebody else. I certainly don't think that is the best way to do that, by having your co-arbitrators deciding for you. And I think that is something that I always found curious. But yeah, I don't know how you would decide that. I think the broader idea that I want, and again, that's something that follows from what I say more than anything else, more than the development of another legal doctrine, is how we make sure that this idea of open-mindedness, and I hope I can discuss that at a later stage on another occasion, is somehow stubbed into the process. This is, I think, should be the real standard, the real test of impartiality, whether someone comes with a views, a predisposition, but they're open to change those. If the facts, if the cases show otherwise, I don't know how we can test that, but I think as a conception of a bright line between permissible and impermissible forms of impartiality, I would draw the line there. And you see, it's one of those cases that you sense, you see some colleagues are not open-minded. The vast majority of them are. They come with strong views, of course, and you should welcome that. But can you change? Are you open to a change? How we test that? Whether there's a test of personality or psychometric test to change your open mind is, I don't know, but I hope we will develop that one day.
Thank you very much for that. And thank you for your questions and your lecture. Fantastic. Well, thank you for being with us today. I think that that we've brought much food for thought. And thank you again, Michael, for honoring us with Stavros professorship. Thank you, Daryl, for hosting us today. And thank you, Maxwell Chambers. We'll see you next time. Thank you.